Good morning. I'm Judge Tammy Long Hayward. This is State Court of Clayton County, courtroom 304. This is the jail calendar for December 30, 2025. We're going to move as quickly as we can through the calendar. If the courtroom is on,
I'm sorry, Your Honor.
it's okay, Mr. Lynch. Good morning.
Good morning, Judge.
All right. So, first case on the calendar is Alexis Clemens.
Judge, that's going to be resolved today. I'd already talked to her about a plea. However, I believe the state made me aware they're going to offer her PTI and consent to a release. And so I need to talk to her about that. We'll have a resolution on that, Judge.
All right. Thank you. So, it's going to either be a plea or PTI, is what you're telling me.
That's correct, Judge.
All right. Thank you. All right. Next is Kayla Garvin.
Judge, I do need to speak with her further. I had taken the time to speak to a family member.
Are there concerns?
There are, Judge, but I need to, based on the offer, I need to really make sure that I just need to have a further conference.
Okay, so here's my concern. If there are possible concerns health-wise, we don't need somebody who's got pedestrian in the roadway and obstruction. Let's see what we can do to get them out and into a therapeutic environment if that's possible.
Yes, and that's her family member. I had discussed with her whether she's released via resolution of the case or otherwise is standing by to come and get her personally from the jail, whatever release we may do. I haven't personally spoken to Ms. Garvin yet, Judge, so I just need to get a better
no problem. All right, next is Cortez Devon Jones. That's a petition.
Judge, that is MJ's case. I believe that is going to be a stipulation. I'll verify that with MJ shortly.
All right. Next case is Jeremiah Leandre Jones. Concerns?
Judge, I know I believe he's competent to resolve his case. He is a frequent flyer and is probably near the
Yeah. Has he been medicated?
I'm not aware of his current status, Judge.
All right. Thank you. Christopher John Odom.
Judge, MJ is conferencing with him right now. I believe that may be a resolution as well.
Okay. Brees Tanner.
Judge, Mr. Tanner is in custody he's in custody for this case with no bond. I did file a motion to set bond. At this point, I am ready to go forward with I believe we'll be going forward with the motion to set bond. Whenever the court is ready.
When was it filed?
I filed it.
Okay, hold on. Does the state have an objection to going forward on the motion to set bond?
Yes, the state would have an objection. What was it?
I can't hear a thing you're saying.
I'll get you the date it was filed, Judge, but the motion was filed ahead of time, Judge, and we discussed it on the record.
Okay.
Let me just pull
This is just a motion to set bond?
Just to set bond. Yeah, he's held with no bond.
It would be helpful if you all could consent to it, but I'll hear the motion if we have to.
Absolutely, Judge. I will, thank you, Judge. I'll talk to the state.
Well, because we may have to.
Yeah.
All right. Next is Timothy Alexander Taylor.
Judge, Ms. Tortorello speaking to him. I believe that's going to be a resolution.
All right, and Mr. Taylor has two cases, so both of the same.
Yes, Judge.
Last case is Jasmine Imani Wilson.
Judge, that's going to be a stipulation, and we'll ask the court to accept the recommendation from the probation office.
Are we ready to go forward with the petitions while Ms. Tortorello is still speaking?
Sure, we're definitely ready to go forward with Ms. Wilson at this time.
All right, let's go ahead and pull up Wilson. All right, Ms. Wilson, good morning, and raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
Speak up a little bit for me.
I can hear you.
Speak up a little bit for me.
You got to speak up.
Yes,
Okay. How old are you, ma'am?
27,
How old?
27.
27. Okay. All right. So, Ms. Wilson, you're before the court. State of Georgia versus Jasmine and Monty Wilson, 2022 CR 022068. This is a petition for revocation of probation. You are before this court for driving under the influence of alcohol on the 20th day of October 2025. You were sentenced to 12 months on probation. You have 9 months and 17 days remaining. Your sentence was not told, but you failed to avoid injurious and vicious habits. You tested positive for the metabolites of alcohol on November 20th of 2025. You failed to report on October 29th, November 11th, and within 10 days of November 3rd of 2025. Also, you failed to report for a hearing on December 19th. I'm sorry, on December 17th. You last reported on December 19th. You failed to complete your clinical evaluation. You failed to pay. You're currently $405 in arrears. Mr. Lynch, what's going on with Ms. Wilson?
Judge, I'm not quite sure what the issue was with the reporting, but
Well,
I
let's
know
ask her.
that
She's right here. Ms. Wilson, what was the issue with you reporting?
I stay in Decatur, Georgia, and it was hard for me to get from Decatur to Clay County.
Okay, so what part of Decatur? Because the train runs to downtown Decatur, which will connect you to a bus here in Clayton County. Miss Wilson, you're 27 years old. Life is going to come at you fast and it's going to pass you fast. You're going to have to grow up. You have a criminal offense, and if you don't take that seriously, you're going to end up in jail for some time. Do you have children?
Yes,
Who's keeping your children while you're in jail?
my child's father.
Mm-hmm. So you spent Christmas in jail, is what you're telling me,
Yes,
away from your children. Okay, so we're going to have to wake up, grow up, and get our lives together. We got that?
yes.
Because if you can't make the effort to get to probation, and I know it's hard, but you can get on we have Metro. And if you're coming from Decatur, I know there's bus service in Decatur. I know there's train service in Decatur. I know it will connect you to a bus. You might have to get up early, but we got a bus that comes right to the courthouse. Are you working?
Yes,
Where are you working?
wild buffalo wings.
The what?
Wild buffalo wings in Stone Mountain.
Okay. Mr. Mack?
Judge, I know that the the probation was going to recommend that she be take community support meetings. She understands that.
Does she? Because she didn't do the reporting. So is she going to go to the community support meetings?
I had discussed that with her and had a little discussion about where she could potentially find some meetings to attend to satisfy that condition. She indicated that she could take care of it.
Okay. All right, Mr. Austin or Ms. Chang? Oh, Mr. Austin.
Good morning, y'all.
Good morning.
Recommendation is credit on time served since 12/19, return back to probation, drug screen every report going forward, attend at least one community support meeting per week, and have clinical evaluation completed by the 15th of January, 2026.
All right, Ms. Wilson, do you understand what that means?
Yes, ma'am.
Okay, so that means you got to get the clinical evaluation done. That's to find out if there is something that you are dealing with that needs further treatment. Do you understand?
Yes, ma'am.
All right. How many children do you have, Ms. Wilson?
One.
Okay. If you want to be a good mama, you got to get yourself together. Okay? Your children are not going to benefit from you being in a green jumpsuit. You got me?
Yes.
All right, get it together, Miss Wilson. You're 27 years old. You're not a child anymore. All right. So, Mr. Lynch, anything else?
Nothing further at this time, Judge.
All right.
Donna,
Yes, Mr. Austin.
I just want to let Ms. Wilson know that Ms. Chang will contact her on her next report.
Does
For
she
her
have
next
good
report.
contact information?
Yes. Anything changed, Ms. Wilson?
No.
Okay.
All right. So, Ms. Wilson, I'm going to give you credit for time served since December 19th, 2025. You'll be released and you'll return to probation, which you have to attend your probation reports, take the metro, and come. You'll return to probation. You'll also attend a community support meeting for the cessation of alcohol or drugs. So that's any group that is a meeting type group, which where you can attend, where the focus of the group is no drugs, no alcohol. You understand? So Alcoholics Anonymous is one type, but it doesn't have to be that one. It just has to be a recognized program. All right, you're going to do your clinical evaluation and get that done by January 15th of 2026. Do you understand?
Yes, ma'am.
If you have questions about where it's available and how it's available, you're going to talk to your probation officer.
Okay.
The quickest way to get rearrested is to keep missing your probation reports. You deprived your child of having their mom present for Christmas. Don't do that again. You understand?
Yes, ma'am.
Get yourself together. All right. And you're going to test at each report. If you test positive again, we're going to have a different conversation. Right?
Yes.
All right. Thank you. You're free to go back.
Are you ready on the fourth day? Sorry. Judge, we're having Mr. Cortez Jones come out.
All right.
Good morning, Your Honor.
Good morning, Ms. Tortorella.
Good morning.
Good morning, sir. Hold on just a second. Let me finish this report, this order. Mr. Jones, raise
Yes,
your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
yes, ma'am.
All right, you can put your hand down, sir. Mr. Austin, my computer glitched and the form cleared, so I'll send that over in a minute, okay?
Yes, Your Honor.
All right, thank you. All right. All right, so Mr. Jones, you're before the court for a petition for a revocation of probation also?
Your Honor, my client will be stipulating to the facts and will be accepting probation's recommendation.
Okay. Not finding it, hold on. There we go. So, Mr. Jones, you were before the court for a petition for revocation of probation on case 2021 CR 05438. You were before this court for speeding 26 to 30 over on the 27th day of February 2024. You were sentenced to 12 months on probation. You have 5 months and 3 days remaining. Your sentence was tolled because you didn't report. So you failed to report on March 12th, April 15th, May 15th, June 15th, July 15th, and in person within 10 days of August 12th of all of 2024. You last reported on March 21st of 2024. You failed to comply with counseling. You were to take a driver improvement course as directed, and you were to pay your $980 in arrears. Mr. Jones, you essentially had to take a class and pay. What happened?
At the time, it was just bad timing. I had a class set up online when I found one that was credible.
No. I told you don't go online. I told you the only class I would accept, because I tell everybody this, don't Google it. Go through the Department of Driver Services.
Yes, ma'am.
Did you do that?
No, ma'am.
So you weren't listening.
No, ma'am.
Mr. Jones, if you don't listen, you end up in jail. I made it real easy for you. I told you exactly where to go. They have several programs you could have taken.
Yes, ma'am.
And it's probably cheaper than the one you found online. What's the recommendation?
Your Honor, served 10 days credit since the day of lockup, which is December 2025. In this case, be closed.
You spent Christmas in jail because you didn't take a class, a driver improvement class, which would have helped your driving record, and you didn't pay the amount of money that you should have paid. Okay, let me just tell you something, Mr. Jones. Don't speed, because it's not going to work out in your favor. Slow down.
Yes, ma'am.
All right. All right. Anything else, Ms. Tortorella?
Nothing on behalf of my client, Your Honor, only that you accept the recommendation.
All right. So, let's see. You said 10 days, Mr. Austin?
Next week.
That's correct, Your Honor.
Even though you hear the police.
Does he have anything else pending?
Your Honor, I couldn't hear you.
Does he have anything else pending?
I don't believe so, Your Honor.
All right, so I have that he should be released immediately on this case.
Thank you, Your Honor.
All right, Mr. Jones, how old are you, sir?
34.
Huh?
34.
Okay, Mr. Jones, you did something really, really dumb because you spent time in jail for something that you could have resolved easily. You asked me for this. I didn't say, hey, this is what you should do. Your attorney talked to you about this, asked if you could complete this, gave you time to do it, and you messed it up and ended up in jail. I could have given you the jail time from jump. We wouldn't be here. When you make an agreement to do something, do it. Otherwise, you end up with consequences you didn't anticipate.
Yes, ma'am.
All right. You're free to go.
Thank you, Your Honor.
Thank you, Your Honor. That's all I have.
Thank you, Mr. Austin.
All right, Happy New Year.
Happy New Year to you too. All right, anybody else ready?
We could do Christopher Odom, Your Honor.
Okay, wait him up. Bring him up.
Please, Christopher Odom. Yeah. Yeah.
What's his first name?
Christopher.
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. All right. I'm sorry, is this Mr. Garvin? No, I'm sorry, not Garvin.
Odom.
Is this Odom? Okay. That's wild. I have a cousin named Christopher Odom. Yeah, not you. So this is case 2025 CR 10958. Christopher John Robert Odom, DUI less safe count 1, reckless driving count 2, impeding traffic count 3, license not on person count 4, giving false name, address, or date of birth counts 5 and 6. Ms. Tortorella, what does your client plead to the offenses before the court?
Your Honor, for DUI less safe, that will be a guilty plea, count 1. Count 2, my understanding will be no prost. Count 3, that will be a no-low plea, Your Honor, impeding traffic. Count 4, no license on person. My understanding is that will be no prost. Count 5, giving false name, that's a no-low plea, and count 6, giving a false name, a date of birth, that will be a no-low plea as well.
All right, so Mr. Odom, by entering a plea of guilty to count 1, count 3 will be a no-low, count 5 and 6 will be a no-low, counts 2 and 4 will be no-prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am, I do.
All right, factual basis recommendation, please.
Cannot hear her.
I can't hear you. You have to approach the mic, Ms. King, the computer, because we're not going to be able to hear you from there. Our audio is not set up well for this.
Okay, so back on November 18th of 2025, officer responded to a person down call in the area of Highway 85 and Forest Parkway in Clayton County. We observed the defendant. He was in a silver Buick at the intersection, stopped at a solid green traffic signal. The vehicle was not advancing, and traffic was driving around it to continue through the intersection. When officer approached the vehicle, he observed the defendant moving his arm erratically and dancing in the driver's seat. After several attempts to gain his attention, the driver appeared startled and attempted to move the vehicle forward before stopping as commanded. When he was able to make contact with his person, the defendant displayed signs of impairment, including confusion, excited behavior, unsteady on his feet, pinpoint pupils, and inconsistent statements. When asked for his driver's license, he stated he did not have it on his person, so he asked for the defendant to identify himself by name and date of birth. He gave the name Kevin Smith, date of birth March 24th of 1986. Officer later learned that his real name was Christopher Odom, date of birth 6/17/1989. And then based on the defendant's condition, officer determined that it was not safe to perform the field sobriety test. He did read him implied consent, to which the defendant refused. The defendant has a prior DUI from 2009. He has one pending in Griffin from 2023, and then one was dismissed in 2024 in Henry County. The state's recommendation as to count 1 will be 12 months, served 35 days, credit for the time served, balance probated, a $500 fine, substance abuse evaluation with any recommended treatment, the risk reduction course. He is not to consume any drugs or alcohol.
Let me ask this. Why is he not a drug court candidate?
Because this would be his first and 5, first and 10, second in life. So he does not qualify. It would have to be second and 5, third and 10, third in life.
And he has one pending, you said, in Henry County?
He has one pending in Griffin that has not yet been resolved. I mean, I can try to refer him, Judge, if you would like, to see if they would accept
No,
me, but I know the
I'm just,
qualifications.
it's my concern that, yeah, nah.
Your Honor, just to let you know, he is actually going to join a treatment program up in Johns Creek. His sister is working on signing him up for the substance abuse treatment. Is it in-house?
It's in-house.
It's
a 2-year
in-house.
program.
It's a 2-year program in-house. So his family is also being supportive and working towards his rehabilitation.
And then
Yeah, I'm feeling like he can't drive. Like, one of the stipulations needs to be that he can't drive.
I would agree with that. Can I talk to you real quick for this one? We were the false name. I think we should run it consecutive with that one, and it would just say continue with no drugs, alcohol, continue with random testing and things like that, whatever. Because he said the program is 2 years.
it's 1 year in-house, and then I can stay for an extra year and work.
So just continue with whatever conditions that program has him on.
Would that help me at all with paying with me being in the program? She was concerned about the.
We didn't agree, we didn't agree to consecutive. I think he can continue the program without having to continue to be on
Okay, well, he's only
probation.
gonna have 1 year to.
Complete the,
Mhm.
But with me being in the program, I think the first 90 days, I don't have to work. It would be all my spare time. That'd probably be good for me to be doing community service, honestly.
Okay. Judge, would you like for us to continue with the recommendation?
I'm sorry, say that again.
You want me to continue with the recommendation? I think we've,
Y'all worked it out?
Yes.
Yeah, go ahead.
Okay, so count one would be 12 months, serve 35 days, credit for the time served, balance probated, a $500 fine, substance abuse treatment, 140 hours of community service work, the substance abuse evaluation with any recommended treatment, random testing. He is not to consume any drugs or alcohol while on probation. He is complete the risk reduction course while on probation. We are asking for him to do one AA meeting weekly until he gets into this program, because it's my understanding he has not been accepted yet. And then count two will be dismissed.
He
Count
can't drive. He's not allowed to drive.
That's right, and then he is not allowed to drive. His license will be suspended anyway after this conviction, but he will not be allowed to drive. Count two will be dismissed. Count three will be a $100 fine suspended. Count four will be dismissed. Count 5 and 6 will be $300 fines suspended.
Okay, and I understand that his license is suspended, but that doesn't keep people from driving. I wanted a specific condition of his sentence that if he's found driving, then he comes back before me as a violation of his sentence.
Yes, ma'am.
All right. All right. So, Mr. Odom,
Yes, ma'am.
come here, sir.
Yes, ma'am.
Mr. Odom, can we agree that you are an alcoholic?
I can agree that I am a substance abuse user, yes.
So it's more than just alcohol.
Yes, ma'am.
All
That's why I
right.
wanna go to the substance abuse.
So recognizing it is the first step, Mr. Odom, there's nothing I could sentence you to that would be worse than if you killed somebody while you're under the influence of alcohol or drugs. And since you tend to alcohol, drugs, and drive, that's a problem.
Yes, ma'am.
If you stayed at home, this probably never would have come to my attention, but you drive. And you're driving in multiple jurisdictions, getting caught in multiple jurisdictions. And the times we've caught you doesn't account for the times we didn't. You don't get to kill, maim, hurt somebody else, take someone away from their family because of your selfish choices. You got me? If you're dealing with a situation and the situation is yours to deal with, that's fine. If you're dealing with it and you're getting help, that's fine. But if you're imposing what's going on with you on other people, that's not fine.
Yes, ma'am.
Just think about how you would feel waking up every day thinking that you killed somebody. Because a lot of times my sentence doesn't mean anything to people. They can do the time, they can pay the fines. But if you wake up every morning thinking about that you took somebody from their family, think about what you would feel in that situation.
Yes, ma'am.
All right. So I'm going to accept your plea. I'll sentence you to 12 months to serve 35 days. Credit for time served. Balance will be probated for you to pay a fine in the amount of $500. It's going to be closer to $700 or $800 because of the surcharges. You'll do a substance abuse evaluation and take any treatment that is ordered. You're also going to do a risk reduction course. You're subject to random screens for alcohol and drugs. You're to have no alcohol or illicit drugs during the course of your probation. You are also going to do 140 hours of community service, and you're not to drive while you're under this sentence. If you're found driving, that will be a violation of the special conditions of this sentence, and you'll end up back before me where I can sentence you to jail time. Also, you will take one community support meeting per week, whether that's Alcoholics Anonymous, Narcotics Anonymous, or any other community support meeting for the cessation of alcohol or drugs. If you get into a treatment program, then the community support meeting, that will be considered part of your treatment program. So you do not have to do a separate one as long as you're in a recognized treatment program. You understand?
Yes, ma'am.
All right. If your family's trying to get you help, Mr. Odom, comply with them and get the help you need, okay?
Yes, ma'am.
All right, anything else, ladies and gentlemen?
Yes, Your Honor, on behalf of Mr. Odom, he has a felony VOP before case before
Yes, a
Judge
what?
Carter. Wondering if, he advised that he is probably going to be heard before Judge Carter within 2 weeks. He has a lot of hours to do in community service, Your Honor, so I'm just asking if you could email Judge Carter just to assure that he's on the next jail calendar so he could be heard on that VOP. If that's
Look,
possible, Your
I
Honor.
can email her, but her calendar is her calendar. I can send her an email telling her I'm sending, like I've completed his case, but not sure that that'll get him on any quicker. That's a felony calendar, so her caseload is a little different than mine. All right, counts 3, 5, and 6 will run concurrent with count 1. $100 suspended on count 3, $300 suspended on counts 5 and 6. All right.
Thank you, Your Honor.
All right. There was something else. Yeah, that's it. All right. You can go with the sheriff's office, Mr. Odom.
Thank you, Your Honor.
All right, who's next?
We could do Jeremiah Jones. Hey.
Okay. Mr. Jones, how you doing this morning?
I'm doing fine. How you doing?
Good to see you.
Good to see you too.
All right, so Mr. Jones, you're before the court on State of Georgia versus Jeremiah Leandre Jones, 2025 CR 10957 for criminal trespass. Mr. Lynch, do you have any concerns regarding Mr. Jones this morning?
Judge, I believe at this time he's competent to enter a plea in this matter.
All right, so Mr. Jones, you're before the court for criminal trespass. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down, sir. Mr. Lynch, what is your client plead to the offense before the court?
Guilty, Your Honor.
All right, so Mr. Jones, by entering a plea of guilty to criminal trespass, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis and recommendation, please, Ms. King.
Take one step to the right, please.
Yes, Your Honor. Back on December 6th of this year, officers responded to the Happy Store located at 7694 Tower Boulevard in Jonesboro in reference to the defendant criminally trespassing. Officer confirmed that the day prior, he had already been given a criminal trespass warning. Based on that, officer arrested the defendant on scene. The state's recommendation would be 12 months, served 30 days. Credit for 30 days. Credit for the time served, balance suspended, do not return. Again, that address is 7694 Tower Boulevard in Jonesboro, Georgia, and then no further violations of the law.
All right, thank you. All right, so Mr. Jones, you cannot go back to the Happy Store, okay? Do not go back to that location, all right? You understand me? They already told you don't come back, so don't go back there. All right, so this is 12 months to serve 30 days, credit for time served. The balance will be suspended as long as you do not go back to the Happy Store at 7694 Terra Boulevard, Jonesboro, Georgia, Clayton County. All right, you can go back with the sheriff's office. Okay, did we get a resolution on Clemens? Is it going to be a program, or is it going to be a plea?
Judge, I'm waiting for Ms. Porterlow to finish up with one person, and then we can get 2 females put in there, and I can.
Oh, okay, I forgot with dealing with the
if-
females and males.
I do have an announcement in reference to Mr. Tanner, Judge.
Go ahead.
So this was the case I filed a motion to set bond. Judge, I did discuss a consent bond with the state. Unfortunately, they are, or from our perspective, they're not, unfortunately.
Y'all aren't close.
Willing
Okay.
to consent. However, Judge, if we could just have a brief hearing on that, Judge.
Yeah, let me ask this. Why was his bond denied in magistrate court?
Because he's on
Does he have
probation.
a
He's on
okay, probation. All right, where's he on probation?
DeKalb County.
And for what charges?
It is a charge involving his father. I'm not sure the exact charge, but I know that it's the alleged victim would be his father.
Okay, I feel like he's entitled to a bond. I'm not sure it is a bond that y'all are gonna appreciate.
Well, Judge,
Are we ready for the hearing?
I am, Judge, and what I was gonna ask for, well, I guess maybe I should
Well,
have him out here before I ask for
I
it.
say we, I
Oh,
got
I'm
it.
sorry.
That's you and Ms. King?
The state is ready, young.
Okay, all right, bring him out.
Hey, can y'all bring Mr. Tanner out? He's in the attorney booth, or he was.
And so as I look at the calendar, so we have, after the hearing with Tanner, we'll have Taylor, Clemens, and Garvin.
Yes, Judge. And I believe Haley Watson is the family member of Ms. Garvin that I spoke with.
Okay. All right, Mr. Tanner, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
I can't hear you. Speak up for me.
Yes, ma'am.
All right, you can put your hand down. So you're before the court, yes?
I'm sorry, Judge, I didn't mean to interrupt. I thought it was my turn. Go ahead.
Not yet, sir. So you're before the court, Mr. Tanner, on 2025 CR 10598, Brees T. Tanner, for battery family violence, count 1, battery, count 2, simple battery family violence, count 3, and simple battery, count 4. It is my understanding that your attorney intends to enter a plea of not guilty and is seeking a motion to set bond in your case. You were denied bond on the magistrate level for, I guess, because you were on probation. So we'll have a brief bond hearing to determine what the bond will be set at, okay?
Yes, ma'am.
All right. So go ahead, Mr. Lynch.
Your Honor, so my client is 34 years old. He does have one child from a previous relationship, and he has a child due in, I believe, February of this year. With the alleged victim in this case, which the bond conditions do indicate that he is to have no contact with, Judge, and he's aware of that, Judge. He was previously working at Crystal's before he was incarcerated in this matter, and my understanding is he likely has the ability to go back there. Additionally, Judge, Mr. Tanner has training as a forklift operator and has a lead on a job at the Randstad factory, which he is planning on pursuing if he is released from custody. Judge, what I'm going to ask the court ultimately to do in this case is to set him either a $2,500 or a $5,000 bond with the condition that he enroll in the family violence intervention program within whatever the court deems a reasonable time from his release from custody. And I've already discussed with Mr. Tanner that the condition of no contact with Kiana Moss would remain in effect until such time as the case is resolved or the court further address that issue, Judge. He is a Clayton County resident. If he is released, he does plan to live with his cousin, who I believe is in Clayton County. He understands that he'll have to come back to court on this, stay in contact with our office. And so, Judge, that is what I'm asking the court to do in this case.
All right, what's the state's position, Ms. King?
Take a step to the right, please.
Yes, Your Honor, I understand that he's entitled to bond. The state's going to be asking for no less than the $8,000 bond. Your Honor, this is based on the defendant's criminal history. In 2019, he pled guilty to something. I'm not really clear what it is, but I know he pled guilty under the FOA, First Offenders Act. 2022, he has a case pending in Atlanta for simple battery family violence. He has another case pending for criminal trespass. That's from 2023. And then he has an aggravated assault for which he pled guilty to in 2023. That was for inflicting pain on a disabled or elderly person. He is on probation for 9 years for that. He was supposed to be incarcerated for 1 year as well. He has now been charged with 2 separate battery family violence cases on the same victim. That's pending with us in Clayton County.
Is there gonna be a transfer?
Well, the state's offer today was to reduce one of them to simple battery. Battery, not family violence, because there was no indication that they ever lived together or that they had a child together at the time. They were not living together at the time. So I don't think it was family violence for that case. And so, but it was for the same victim and there were injuries. In that case, the defendant, I believe it's the one where he was trying to take her keys. She was trying to get her keys back and he continued to bite her on her arms multiple times. An officer did observe injuries to that effect. And then there was another case with the same victim. They were living together at the time. She was pregnant. He was in the bathroom for a while. She went to check on him. He was passed out. And then when she woke him up, he got upset. And then she attempted to leave and he went to put his hands around her neck. I think that was unsuccessful. So she sat on the bed. She kept trying to leave and he kept pushing her down. She grabbed something and then he ripped it out of her hand so hard to the point where it took her nail off. There was an eyewitness there who observed the defendant being violent and physical with the victim, and she is the one that called 911. And so the defendant clearly has a history of violence toward other people, specifically with people that he lives with or that he is in a relationship with. And so based on his criminal history, Your Honor, we are asking for the bond be set no less than $8,000. In addition, we are asking that he has absolutely no contact with this victim, that he not consume any drugs or alcohol while on probation, that he not possess any firearms, and that he does complete the family violence intervention program.
All right, Mr. Lynch.
Judge, I think that you have enough to make a decision. I would point out that my client, as far as the facts, there's always another side to every story, but I'm not going to try the case here before you, Your Honor.
No.
So I would just ask that I understand what the state's asking for. I do think with the additional condition of completing the family violence intervention program, Judge, I do think he would be able to make a bond in the amount of $5,000.
Okay, here's my concern. Mr. Tanner has usable skills. He's a forklift operator. That pays money. There are jobs looking for forklift operators. Yet he's working at Crystal, probably because of his history. The issue that I have is he keeps going back to these same situations where there's conflict. And if there's 2 sides to each story, if the side that he's presenting is that the conflict is with the other individuals, then you would step away from that. Yet he's back with Miss Moss, and not only do they have a child who's existing, they made another child.
Well, Judge, not that it matters. He has a pending child with Miss.
Okay, so Miss Moss and he made a child, even though their relationship was horrible. Yeah, Mr. Tanner, this is a hard one for me, because I know that it's a misdemeanor. You're entitled to a bond, but what this is looking like is, absent the reduction, you'd be facing a felony for one of these charges. You're also facing or have faced other felonies. The issue is whether one of the factors in considering bond is whether you, when I release you, you'll reoffend or you will affect the testimony of a witness. In this case, I have concerns for both, that you will reoffend and that you will affect the testimony of witnesses in your case. There's a lack of self-control, and so that is a concern for me. Setting the bond high doesn't mean anything to me because you would either make the bond and get out and still do what you're going to do, or not make the bond and just be sitting in jail. So you would have a bond, but I mean that'd be the same as a no bond. So the concern that I have is while I believe you're entitled to a bond, I don't know that I have to be lenient in any way. I don't know that you will understand and appreciate the effect of if you were to violate my bond conditions. Not only would you be subject to coming back before me and possibly being jailed until such time as your case is resolved, but you could also be charged with additional misdemeanors or felonies. The concern I have also is you have a baby due in February, and when people have babies due, they tend to forget the violence that preceded um, that was present in their relationship because, oh, it's a new baby and I want to be there for the birth of my child. And then the victim will say, well, I want him to be there for the birth of his child because for some reason, a child seems to erase all of the violence that happened beforehand. And I don't want to have to deal with an issue where you show up to see the baby and then I have to incarcerate you for that. It's a lot of moving pieces here, sir. A lot of moving pieces. You understand where I'm coming from? You don't have to say much, but if you understand what I'm dealing with, nod your head. Okay. So the issue that I have is, do I jeopardize a mother and a newborn by letting you out? Because I don't think you're going to listen to me when it comes to a stay away because of the emotions surrounding a newborn. Mr. Lynch?
Judge, he just indicated that he would refrain from having contact until such time as.
Yeah, then he has a baby, and then I hear, well, she tried to keep me from seeing her son, my son. It's my son. How's she gonna keep me from seeing my son? That's the issue I'm dealing with. Now,
I understand.
there's legal and then there's practical. The
Right.
legal tells me that in the Ayala factors, he's a bad risk. The practical tells me that he's a horrible risk.
Judge, I know that he does want to get out to gain employment to hopefully be able to contribute financially to his existing child.
Well, he could have been doing that before.
I understand that, Judge, and I believe he was making efforts and was doing so to the extent that he could. Your Honor, I would, if Your Honor wanted to set a status hearing as to, I guess, a compliance hearing, something of that nature.
Because all that's going to do is give me more to do and the court staff more to do. All right, $5,000 bond, a family violence intervention program, no contact with the victim in this case or in the pending case in DeKalb. If he misses more than 2 of the family violence intervention program meetings, then he'll come back to jail.
Judge, did you want to set a time frame for him to enroll in the family violence intervention program?
From the time he leaves jail, he will have 10 days to enroll. And he has to show proof of having enrolled. If he fails to enroll within 10 days, he'll come back to jail.
Thank you, Your Honor. I will have
Mr. Tanner, let me talk directly to you and be real clear, sir. If you violate the conditions of probation, of your bond, then I will definitely entertain a motion to revoke bond. I will definitely entertain an argument to put you back in jail. I will definitely entertain an argument that you should be charged with additional misdemeanors or felonies. I will definitely entertain the argument that you should not be let out again until such time as all your cases have been resolved. Do you understand me?
Yes, ma'am.
You have a child that's due in February. Unfortunately, you're going to miss the birth of that child. You're going to miss the first few weeks of that child's life. And let me be real clear with you. Look me in my eye when I tell you that even if you are contacted by the alleged victim in this case, you are not to respond. You can keep a record of that contact, any contact made by the victim of any case that is pending to you, and share that information with your attorney, but you are not to respond. Are we clear?
Yes, ma'am.
Okay, because I'm not persuaded by people saying, but you know, I had a baby. That to me is the worst, because if you know you're making babies, then you also govern your behavior so that you're not in jail when these babies are here and need you.
Yes, ma'am.
So if you want to make babies, don't do crimes. If you want to do crimes, don't make babies. We clear?
Yes, ma'am.
If you go anywhere near the child, the mother, the hospital, anything, I want you to understand I'm so clearly how I feel about that. Because you're facing the felony of aggravated stalking, which is punishable by up to 10 years in prison, a $10,000 fine, or both if you violate my bond conditions. Do you understand?
Yes, ma'am. Yes, Your Honor.
All right. Don't play with me, Mr. Tanner, because you've gone too far with this whole anger, lashing out, violence thing that you got going on, and you need help. But nobody's going to tell you you need help. I'm telling you, you need help, because this is no way to live your life. And if you want your child to end up in a red or orange jumpsuit around the time I'm ready to retire, then you keep with this behavior. Because this is not, you're not modeling a good father behavior. Anybody can create a child if they have the physical ability to do so. But the ability to be a father who makes a difference in their child's life, that requires intention. And you don't have that intention. You just out here creating babies for somebody else to take care of. Because if you're in prison or in jail, you can't take care of them. Are we clear?
Yes, Your Honor.
So when your attorney says, well, he wants to get out so he can, care for his child or his children, if you intended to do that, then we wouldn't be having this conversation. You would never have come to my attention. If that is your intention, then you work, you don't get in trouble, you contribute to your children, you spend time with them. But, any lawyer can tell me that, but that's not what I see in you. You're not putting your kids first. All right, you can go back with the sheriff's office. Draft the order, Mr. Lynch.
Yes, Your Honor. Are you done with that? We put Garvin and Garvin.
Hey, can you bring Mr. Taylor out, please?
Basically, if you heard some conditions.
Ms. Tortorello, is this Garvin, Kayla?
No, I'm bringing out Mr. Timothy Taylor, Your Honor.
Okay, that's fine. Mr. Taylor?
How you doing?
I'm good, sir. Good morning. So raise your right hand to the best of your ability. I know you have the cuffs on. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hands down, sir. So, Mr. Taylor, you're before the court on two cases, 2019 CR 07512 and 2019 CR 07513. On each of the cases, you're charged with one count of theft by shoplifting. You're represented by Ms. Tortorello, who's with you, Ms. Tortorello, on each of the cases, what does your client plead to the offenses before the court?
Your Honor, this will be a non-negotiated plea. For case number 2019 CR 07512, he will be pleading guilty to that. We are asking for 12 months to serve, 26 days, credit for time served, balance suspended, and do not return to the incident location of Texaco. For case number 2019 CR 07513, theft by shoplifting, that will be a no-low plea. We're asking.
Is that the non-negotiated part?
Yes, they're both non-negotiated, Your Honor.
Okay, and you said, all right, and then what's your recommendation for that?
12 months is served, 10 days, credit for time served, balance suspended, $500 fine suspended, do not return to the Shopwise package store.
All right, Miss King, what's your recommendation?
So it's my understanding, I'm assuming he's homeless. I think that's what Ms. Tortorella told me. So I was trying to figure out what would be best for him, be it community service, theft by shoplifting, of course, $100 fine, or maybe we can even add some more jail time. But the state is requesting some type of, recourse for these two cases. So I don't think we really came to a resolution. I know
Well, here's the issue. So it's a 2019 case. Has he had any subsequent theft by shoplifting?
He has not, done.
Okay, so the 2019 was COVID. It was a really tough time for a lot of people. I'm willing to be somewhat compassionate, seeing as how Mr. Taylor seems to have some physical difficulties. And he may be suffering from some things that would make it hard for him to resolve or to attend some of the classes and things like that. And because he doesn't have any subsequent history, I'm tending to want to go with a credit for time served and a no go. The only difference is, I guess Ms. Tortorella was concerned that a subsequent, like getting a guilty on the second one would result in a felony. Is that the case?
No, it would have to be 4. Your 4th.
Okay.
He doesn't have any prior theft by shoplifting.
Okay, so this is what we're gonna do. I'll accept a guilty on both, but I'll accept the recommendation for time served on both, and the no contact or no going back to the locations.
Okay.
All right. Because I'm going to recognize that he's had no subsequent issues. All right, so Mr. Taylor, by entering a plea of guilty to the case 2019 CR 07512 and 2019 CR 07513, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And sir, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir? Thank you. All right. So we have the recommendation. I'll just need the factual basis.
Thank you,
Ms. Tortorello, if you want to stipulate, I'm fine with that.
I'll stipulate to the facts, Your Honor.
Okay. All right. So Mr. Taylor, on the case ending in 07512, 12 months to serve 26 days, credit for time served, balance will be suspended as long as you do not go back to the Texaco. May I have that address, Ms. King?
Okay. Because I think it was 2 different locations for each one.
She's going through this one first.
One second.
I apologize, Your Honor. Give me one
No
second.
problem.
It is 4192 Jonesboro Road in Forest Park.
All right, and may I have the address for the Shopwise?
It is 5001 Jonesboro Road in Forest Park.
All right, so Mr. Taylor, so you're not to go back to the Texaco at 4192 Jonesboro Road, Forest Park, Georgia, Clayton County. And on case 07513, I'll sentence you to 12 months to serve 10 days. Credit for time served. Balance will be suspended and $500 fine will be suspended as long as you do not go back to the Shopwise at 5001 Jonesboro Road, Forest Park, Clayton County. So if that's a shopping center, just stay away from the whole shopping center, Mr. Taylor. Do you understand? All right. Before you leave jail, if you want to ask to see a chaplain, they may have some information about how to help you transition back out of the jail back onto the street. Okay. All right. Take care of yourself, Mr. Taylor. All right. Thank you.
Thank you.
All right. So we have Garvin and Clemens remaining.
Your Honor, Attorney Lynch has some announcements, so we're gonna have to hold on those for a second.
He has some announcements.
Yeah.
Okay.
Your Honor, Ms. Clemens does wish to take advantage of the state's offer, which, as I understand it, is that the state would not object to an order releasing her unsecured judicial release for her to enroll in, or for her to submit a referral form to the pretrial intervention program and then complete that program, unless for some reason she was rejected, in which case she would have to come back to court to address the charges, but she is eligible and has no previous conviction, so that should not be an issue. And that's what we're asking the court to accept.
Can we get her on a status calendar for 30 days out, Ms. Val?
Yes, 30,
I'm sorry.
yes, you can get on the status calendar for 30 days out.
Thank you. We'll go ahead and you can just go ahead and send notice if you need to.
Okay.
All right. Okay, so is she good with bond? Because she's still in.
No, Judge, I'm going to have to submit an order. I was going to submit an order for unsecured judicial release to facilitate her to be able to take this offer because she's not able to make bond on her own. So that would, and the state does not object, is my understanding, but that would have to be part of it.
And yes, Your Honor, the state does not object. We're just requesting that the bond include no violent or harassing contact
Yes, ma'am.
with the victim. The victim is her sister, Ms. Lisa Marie Miller, that's common spelling. And then we would ask for the same no violent or harassing contact with her mother, which is where she is going to live.
Okay.
I'm sorry if I could put her mother's name on the record.
Okay. Well, Mr. Lynch, draft the order for me and send it and I'll sign it today.
Okay, I'll give you that.
Okay. And so hopefully she can be released today. And give her my speech. No violent or harassing contact means exactly that. If she violates, then she comes right back to jail.
Absolutely, Judge.
Okay. All right.
Judge, could you guys repeat, is this some type of program? Just for
Yeah, she's going to pretrial intervention, Ms. Powell.
Thank
And then Garvin.
Yes, Judge. Ms. Garvin is going to be a negotiated plea today. I would note that her family member is on the call and may indicate she wishes to be heard.
Okay, Garvin is our last case. Are we ready to go forward?
We are, Judge.
All right, bring her out. Are there concerns?
Judge, I do not have any concerns as to her competency. I do believe there are likely very serious concerns as to her mental health. However, I have no bona fide doubt at all as to her competency to enter a polluted pedestrian on the roadway. And I think if we were to, I believe if we were to assess
She
that, she would-
understands and can assist, but there might be some other stuff going on.
Absolutely, Judge. That's my understanding. And from speaking to her, I think this is in her best interest.
Good morning, Ms. Garvin.
Good morning.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
You gotta speak up.
Speak up for me.
I do.
All right, you can put your hand down. So, Ms. Garvin, you're before the court on 2025 CR 10959 for pedestrian on the roadway and obstruction of an officer. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, it'd be a no contest plea to count 1. Count 2 would be null prost.
All right, so Ms. Garvin, by entering a plea of nolo to count 1, count 2 will be null prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor, I do.
All right. Factual basis recommendation, please.
Take a step to the right, please.
Your Honor, back on December 12th of this year, officer had responded to the area of I-75 North at Charles Grant exit in reference to multiple calls. Multiple people had called in reference to an individual walking on the left shoulder near the highway. Upon arrival, they made contact with the defendant. They asked her multiple times what her name was. She wouldn't give it. All she would say is that she needed help and that she was going to a homeless shelter. Officers then transported her off the exit. The state's recommendation was 12 months served, 17 days, credit for the time served, balance suspended, no further violation of the law, and then we will be no crossing count 2.
All right, Ms. Watson, you had you wanted to make a statement on behalf of Ms. Garvin?
Yes, ma'am. Would you like me to turn on my camera?
Yes, please.
Thank you, Your Honor.
Raise your right hand for me. You solemnly swear or affirm any testimony you give will be true.
Yes, ma'am.
Okay, you can put your hand down. So, Ms.
Thank you, ma'am.
Watson, how are you related to Ms. Garvin?
I met Kayla a few years ago, and I've been very close friends with her over the years.
Okay. All right, let me know what you need me to know.
I think that Kayla is in a position of she really needs help. She does not want to accept help, but she knows that she needs it. She just wants to figure it all out on her own because she does not see value in herself at all. She doesn't see herself as worth it. And I wish that she did. And she deserves to see that.
Does she have any family members who may be able to assist in her getting help?
She does. She does have family.
Are they willing to help?
It's to the point that they are not willing to help. They are willing to help from a distance.
Okay. So there's something called caretaker fatigue, where people who've been trying to, I guess, manage someone who has maybe a mental health issue, they get to the point where, especially with somebody who's an adult, they can't control the adult's actions without a guardianship. So it becomes harder and harder to get them assistance without that ability.
Yes, ma'am.
So I get it. And Miss Garvin is absolutely worthy of everything
I
that is
agree.
good in this world.
I
Everybody
agree.
is. But it may be hard for her family to navigate. It's very hard also
They've been
for,
hurt a lot.
yeah, for family members and friends to assist someone who's an adult with mental health issues. If you are in contact with them, I would suggest that they seek a connection with the organization NAMI. It's the National Alliance for Mental Illness, NAMI.org. They also have a Georgia chapter. It's www.ganami.org.
Okay.
And these are organizations that have assistance for not just the person who has the illness, but also for family members and caretakers who are trying to help them navigate the situation.
Mm-hmm.
Okay.
Okay.
Um, there's not a whole lot we can do for her with the programs that we have here. There are more programs available on the felony level,
Mm-hmm.
but we're going to try and get her some information to help her transition through the chaplains that work at the jail.
Yes, ma'am. And Your Honor, may I add in one more additional item?
Yes, ma'am.
I have not left yet, but if I am given the green flag to leave, even though I am 5.5 hours away, I will drop what I am doing to come and get her so she will be safe and she will have support.
Ma'am, that would be fine. And I'm not sure how the jail is running with respect to out processing,
Mm-hmm.
but there's if you want, I can put if Miss Garvin, are you willing to go with Miss Watson?
I have other arrangements made.
Okay, so Miss Watson, Miss Garvin has stated that she has other arrangements, and I can't force
Yep, I
help on
understand.
her. Okay,
Mm-hmm.
but she does know she can hear you, and she knows that you're available should she need you.
Thank
And
you.
All
Ms.
right.
Watson,
Thank you for weighing in on this.
I did
Yes,
want to,
ma'am.
I know I did make some statements that we were going to go down that direction, but based on kind of my duties and our conversations, that I may have made some assumptions that were not correct there.
No, Miss Garvin is fully capable of making decisions in her life. So those are absent a guardianship or conservatorship. There's nothing that anyone can do to take away her agency as an adult. Miss Garvin,
Yes, Your Honor.
look at me, ma'am. Okay, you can look up. There's nothing to be ashamed about. Everybody is struggling with something. You got me? Everybody has something in their life that they struggle with. And so I just encourage you, first of all, before you leave the jail, just ask to speak to a chaplain and see what resources they have to assist you with transitioning back onto the street, okay, and out of jail. They may have housing assistance. They may have other assistance that could help you kind of navigate this because it is going to be very, very cold this week. And the last thing I want is you or anyone else on the street without appropriate resources, okay?
Yes, Your Honor. Thank
All
you.
right. If your other assistance doesn't come through, Miss Watson has indicated she's willing to help you, and you just may need a little bit of help to move forward.
Thank you, Your Honor.
All right. But like I said, it's going to be very, very cold. And so I don't want you just out there with nothing. All right. All right. So I'm going to accept your plea of NOLO 12 months to serve 17 days, credit for time served. The balance will be suspended as long as you have no new violations of the laws of the state of Georgia. Count 2 will be no prost.
Thank you, Your Honor.
All right. All right. Thank you, ma'am. All right. So unless I missed something, I think that concludes our calendar for today.
Yes, Judge, and I'll be working on 2 orders to send.
Yeah. Just go ahead and send those to me when you get them done. Thank you all. I hope you all have a safe and happy new year, and I look forward to seeing you. We have trial on the 5th.
Happy New Year.
Oh, sorry, Judge.
Happy New Year, Judge. Bye.